matters consolidated with CV 2025-065754. Can counsel please announce their appearance, beginning with plaintiff's counsel?
Good morning, Your Honor. Lauren Reynolds for Seth Properties, LLC, Dr. Nikesh Seth, and Global Pain Solutions.
Good morning, Your Honor. Tanner Murphy with Hecht Partners for Anodyne Holdings, LLC, Anodyne Pain and Wellness, Inc., and Integrated Pain Consultants, LLC, as well as my colleague, Adam.
All right, well, welcome to you all. We're here for a hearing on the Rule 26D Joint Statement of Discovery Dispute filed on August 4th, 2026. That really relates to the request to amend the scheduling order. So I wanted to start by kind of giving you my approach to these kinds of disputes and my thoughts in this case in particular after reviewing your joint statement and taking a look at your existing deadlines. So obviously, we're always trying to meet the administrative order, the Supreme Court's directive that we try to get civil cases resolved within a certain time frame. And of course, Rule 26.2 also encompasses or incorporates timelines for discovery. But the reality is that civil cases, especially complex or commercial cases, sometimes take longer than those presumptive limits. And I also am balancing the desire to get things resolved against the goal of having cases decided on their merits, allowing both parties time to complete disclosure and discovery meaningfully so that the case can be truly tried on its merits. So in considering those two things, my inclination is to grant some extensions, but not a wholesale 90-day extension of every deadline, which is what is requested. So what I was hoping to understand from looking at the joint statements, it seemed to me that what's really driving the request for an extension is experts, which is not unusual. They can sometimes take longer, especially when you have summertime personal conflicts to get their reports out. So I wanted to ask if that's really what's driving the request for an extension and try to see if we can work into an extension that accommodates the need without just extending every single deadline unnecessarily. So I'll start with you, Ms. Reynolds. Is that right?
Yes,
your name doesn't show up on the little screen here, so I have to use my memory. Can you tell me, is that what is driving your request to extend the deadlines? Is it really the concern about expert deadlines that are coming up?
Yes, Your Honor. It is the concern about expert deadlines. Given I would have gotten into that a little bit more in the joint statement, it's just we're limited on space there. But yes, that is the main driver. And if we can get a 90-day extension on that, I've worked with counsel other counsel many times on kind of making the other deadlines try not to move as much. Yes.
And so 90 days on the expert deadlines right now, I assume you have already met the June 26th deadline of disclosing areas of expert testimony. Is that right?
Yes, Your Honor.
So you're looking for an extension of the identity and opinions, which is a simultaneous disclosure on August 28th, and then rebuttal deadlines of October 9th to be pushed back by 90 days, which would have you basically pushing your initial expert reports back to the end of November. And if your rebuttal opinions are going to be due, well, here you have them due, let's see, about 6 weeks later, then your rebuttal opinions, if we were to bump them back by 90 days, would be probably pushed back to mid-January.
Yes, Your Honor.
Okay. Let's just talk about those two deadlines, and then we can talk about how, because of course it is, I know it's going to have an impact on some of the other deadlines too. But I don't know who's arguing today, Mr. Murphy for Anodyne or Mr. Rader?
I will be, Your Honor.
Okay. Tell me, just on the two deadlines, do you have an objection just on extending those two deadlines? And if so, is it an objection to extending them at all, or is it an objection to the time requested, the 90 days, and would you be agreeable to a lesser extension? I just want to gauge your position just on those two deadlines.
Sure. I suppose the most succinct way of putting it, based on Your Honor's preliminary statement at the beginning of this call, we're not going to sit here and say absolutely no extension. I think 90 days is now getting into a duration of time that comes close to to doubling the time for expert reports. And to Your Honor's point, I think a 90-day extension, the only way to do that would be to move all, if not close to all, deadlines in the scheduling order, in the operative scheduling order. So with that, to come full circle here, I'm wondering if there is a way to extend the expert report deadlines 30 days or 45 days, maybe split in the middle at 45 days, and thereby also allow the parties to leave some of the other deadlines on the calendar as is.
Ms. Reynolds, can you tell me, 90 days is a pretty long extension for experts, especially when you already have disclosed areas and presumably have retained experts. Can you tell me why 90 days and whether we can come to a compromise that's less than 90 days without that being an impossible task?
Yes, Your Honor. So I think the timeline and procedural history are important here because the experts that we have to do with our affirmative claims that were, they had been subject to a motion to dismiss until Your Honor's ruling in mid-June. And then they were not answered until the end of June. And we were able to get out discovery in connection with those affirmative claims, they were, because of the way things were consolidated, counterclaims in the consolidated case. We were able to get those out in early July, on I believe it was July 7th. And so we still haven't received the responses to that discovery yet, although opposing counsel has provided us with some documentation. There is some important documentation as to certain parties' financial information that we do require, and we're not sure whether or not that's going to be subject to some sort of discovery dispute or some other issue. I believe those are due next week. I'm hesitant to ask for less than 90 days because it has been difficult to obtain even short, agreeable extensions of time as I might expect in other cases. And so I am hesitant to ask for less than 90 days.
Okay, and so you're waiting on some discovery responses that you'll get next week. And is that all you think you need, assuming those responses are complete, to turn over to your experts to have them prepare whatever reports they need to prepare?
To my immediate knowledge, yes, but since my experts haven't looked at that information yet, I cannot affirmatively say that that's all they need. If there's something else that they need, we would ask for it immediately.
Okay. Here is what I'm going to do. I'm going to grant the request for an extension, a 90-day extension on expert deadlines. That is going to impact the final discovery deadline, expert depositions, and the mediation and dispositive motion deadlines, which I will set back out based upon the new deadlines in my order following today. However, I'm going to emphasize that I'm not going to grant any other extensions unless there is some extreme unexpected interruption in your process that requires it. And if it's not by agreement, then you're going to need to file a motion, not a discovery dispute, because I'm going to want to really see what justifies any further extensions. And so here's what I will do. I think it'd be easier if I go offline and just track your existing scheduling order and set new deadlines in my minute entry from today rather than going through them all online. But as I said, the one thing I'm not inclined to move, though, is the deadlines that are associated with written discovery to the parties and lay witnesses. So I plan to leave those in place because I don't see any reason, or haven't heard any reason for why those deadlines should be extended. Does anybody have any disagreement with why my extending the expert deadlines would require extending lay witness deadlines and written discovery deadlines?
No, Your Honor.
No, Your Honor.
Okay. All right. So I will get that out to you so that you have new deadlines you can calendar. As I said, I'm going to extend 90 days, the 2 expert deadlines, and then I'm going to push out the dispositive motion, the final complete discovery deadline, and your mediation deadline, because I think it's generally helpful for you to have expert disclosures before you head into a mediation. And we'll reset the trial setting conference based on the new deadlines, and you'll get that in my minute entry following today's hearing. Okay?
Thank you, Your Honor.
All right. Anything else we need to talk about today?
No, Your Honor.
No, Your Honor.
All right. Thank you. Have a nice day. We're off the record.
You too. Thank you.
You too. Bye.